Camera on Eddie. And for our next segment, we have one of our best friends from Family Law Software, Anna Taitt. Anna, how are you today?
Good. Thank you for having me.
This is like our 8th anniversary of knowing each other. You know that?
I'm not surprised because I think I'm like 9 or 10 years with FLS, like in August. Yeah, it's been a long road.
So I've known Anna all this time because I'm a big fan of Family Law Software, and she is the what district do you represent, or what's your geo area?
So now I'm the director of family law sales and training with Family Law Software and Centerbase.
Wow. So congrats, and thank you for taking the time today. And we're going to talk about the new alimony bill and some fun stuff and get into how Family Law Software deals with that. So these are cool computer credits. So thanks for the tech. So I'll throw it over to you, Anna. I think you have a PowerPoint for us, right?
All right, awesome. So let's share the screen, my PowerPoint presentation. Let's make sure it's the right one. What did I just do? Sorry about that. And then let's go to presentation mode. All right, perfect. So you're seeing my PowerPoint, not the...
I see a PowerPoint.
Hold on. I just want you to see the slide. Share that. Okay, perfect. All right, so Family Law Software. So we are a tool, obviously, for financial affidavits and child support. And so today we're specifically going to talk about alimony in Florida. And so unless you've been hiding under a rock, we've got new rules. And so what's interesting is Florida might have felt like the crazy Wild West when it came to alimony spousal support, but to be honest, there are less than 10 states that have guidelines. And so Family Law Software has now, Florida has joined those states and now has statutory guidelines for spousal support. So in the statute, we don't really have any new terms. We have bridge the gap alimony. And the new thing is that it cannot exceed the 2 years. So that's going to be transitioning from married to single. We have rehabilitative alimony, and so that's all about making a plan, and that plan is to become self-sufficient and supportive, and that cannot exceed 5 years. Durational alimony is still around, and it's been made abundantly clear that that is spousal support for a set period of time, and that's going to be based off of the term of the marriage, but if you were married for less than 3 years, it's not applicable. And last, which is the big one that everyone knows, is permanent alimony is gone. So it's just gone. But the question is it really gone? And so that's a question for everyone to debate, and let's see what happens, because under exceptional circumstances, it may be extended.
Can't wait to see the cases that discuss that, because it's not in the statute.
So that will be interest. How long do we have to keep going back? Is it till XYZ? And so there's a lot more to read into the new statute when it comes to retirement and all types of things. But for today's purposes, we're going to focus on just these types of spousal support. Need and ability to pay. You still have to have a need, and there has to be an ability to pay. So that has not gone away. As far as the ability to pay or available income for alimony, we're going to look at net income, and that is going to be the same net income that you would use for child support purposes. Of course, when you calculate child support, you already know what spousal support is in theory. And so if there is temporary spousal support, it would have to be excluded from that. And then last is the need. We still have the standard of living is going to be a part of the statute. And what's new and interesting, I think, is that the bill says, and the anticipated needs and necessities of life for each party. That is new. And so what I love and find interesting about that, the anticipated needs and necessities, is when we build financial affidavits, one of the basic questions I get, and I love because I think it's a fascinating question, is when I fill out this financial affidavit for my client, is it current income? Is it average income? Is it the expenses today? Is it the expenses that we think post dissolution? And it's a great question. I don't know the answer to that. But this opens up to the clear rule that anticipated needs and necessities are now something that you can factor in. So when you file a financial affidavit, maybe they're living with their mom and dad during the pendency of the case and their expenses are very low, but we know that that's not sustainable. They need to be independent. And so my financial affidavit might now say, well, this is average rent, like this is what they're going to need. So the anticipated needs and necessities, but it's for both parties. So it's not just the person, not the recipient. It would be the payor as well. So I don't know.
I think that fixes a big issue, because before we were stuck with actual expenses, which may not reflect someone's need post-divorce. So I kind of like that part.
I love it. And I think it makes sense. So for those of us that had been marking estimated for every line or footnoting for every line, I don't think that's going to end. If that's the way that you create your financial affidavit, you might still want to do that. But I think this gives a lot more guidance as far as what you can put on it. All right, so the big one, number one, we went over that there's going to be 3 types of spousal support, and I use the terms interchangeably: spousal support, maintenance, alimony. It means the same thing, obviously. So number one is that you can have a combination of the awards. Durational alimony in particular, the statute says that number one, it's the reasonable need of the person, or not to exceed 35% of the difference between the parties' net incomes, whichever is less. So when you're building your financial affidavit, or when you're talking about your client's budget, you got to find out what the need is, figure out what the max is, and know you're going to get whichever is less. The tricky one is going to be bridge the gap and rehabilitative alimony. We don't think it falls under that 35% difference of the party's net income. We think it's different. And we think that the standard for that is going to be that it cannot leave the payor with significantly less income than that of the recipient.
I wonder what that means.
Great question.
55%, like, I don't know.
I know. It was there before, it's still there. The question is, what does that mean? As a person who likes math, when you read the cases that are out there, we know that there's a string of cases that says, if you leave the payor with $1,000 for food, rent, gas, that's not enough. Like, that's not nice. We also have cases that specifically cite 60% of available income as being if the award of support is 60% of the payer's income, it's too high. I think there's a couple of cases that cite like 56, 57. So once you're over 50%, I guess you call that the danger zone as far as like available income. Or if your support is that high, as a practitioner, I would be thinking, why is this person agreeing to this? I'm thinking that there's hidden money, or this person's, they're just done. They're over this process and they'll agree to anything. I don't know, but it's important to find out about how the support impacts both the payor and the recipient. And then last, there's specific findings. So again, the need and the ability to pay. So that's all that's still around. So we've got to keep that in as the standard.
All right.
All right. So today, let's get into some tech credits and start talking about some numbers. So first, I want to talk about net income. We want to talk about the gross to net income and how gross income is reduced through the statutory deductions that have not changed, and then tax credits and liabilities. We also have 50-50 time sharing now. So we're not going to get into that, but we will talk about how 50-50 time sharing cases can impact child support and available net income because of tax credits related to children. We're going to talk about the duration of alimony, max alimony, the impact, that's the big one, and present value, because you can still have lump sum alimony. So I'll be demonstrating all of this using family law software. That's not to say that you couldn't figure this out using other tools, using an Excel program, pen and paper.
So Anna, let me just ask you a question to make sure that family law software currently has all of those features embedded, and you just go into the web version of it and you have access to all of this right now if you subscribe, right?
Correct. So if you are using family law software, we already have an alimony calculator based off of the new statute. We have all of these tools available. And so we're going to talk about the calculator that's been added, but we're also going to talk about like these comparisons, because leaving someone with less net income than someone else less, what does that mean? We're going to show you how to get those percentages out so that you can show your fact finder and they can say too high, too low.
Let's get into it.
Let's go. Perfect. All right, so now what you are seeing is family law software cloud-based. And the first thing that we want to talk about is how much money is available to pay for alimony. And so it's a pretty straightforward question if you've filled out your child support guideline worksheet. So what I'm going to do is, this is our official child support guideline worksheet, which is the Florida Supreme Court form. This is the net income that we are talking about for child support. And it is also the net income that we are going to use for the beginning of our alimony analysis. So you have to get to this number. This number on a child support guideline worksheet could already have alimony included in that line. So if your child support guideline worksheet already has alimony considered in there, it has to be removed from that line. So normally that would be a part of that calculation. So how do you get to this number? So let's go into Family Law Software's child support calculator just so that we can see a little bit about that. So you can see that our child support number is at the top, and then we don't really see our net income until we go to the printout. So the reason I wanted to come here first is that one of the major differences or issues, if you've ever run child support and had a different result than the opposing party, your fact finder, your judge, it's probably because of tax issues. And so now you can see here, these are the overnights in family law software. We're not going to change this. So in our calculation, when you come here, one of the parties is going to have 365. So we'll just say the first party has 365. And so when it comes to IRS rules, whoever is claiming the child for tax credit purposes, the majority time sharing parent would be entitled to all of those. And so the child tax credit is going to be the big one. For lower income parties, the earned income tax credit is going to have a huge impact on your final net income. And so if you are going to start running your child support cases more often with 50-50 time sharing, family law software allows you to do that in two ways. So first, you could enter 183 overnights for each parent, which is effectively 50-50 time sharing. And what effectively is what federal guidelines are going to say. That extra night has to go somewhere. And you are also able to run child support in family law software and some other programs too with a real 50%, so meaning 182.5. So the only thing I want to caution practitioners in general is if you're ever running a true 50-50 time sharing schedule, you really have to pay attention to who is claiming the children for the child tax credit and any other credits that could follow children. In family law software, it's really easy because you have this drop down. So I can see that mom is claiming child 1 and dad is claiming child 2. And we see the impact on child support. And then obviously there's an impact on net income. So in the future, if you're running more of these 50-50 time sharing cases, just really pay attention to those little things because you can see huge swings in child support and net income for your cases. All right, so now let's jump into alimony. So these are the 4 folders that we have in family law software to help analyze your alimony cases. We were just kind of talking about net income, so we'll come in here second, but first we're going to talk about the term or duration, then we'll talk about income, and we'll talk about the other folders. And so let's start with alimony term. So I have the sample file open for family law software, and so if you were to do the same, you could see the exact same numbers and parties, but we're just going to focus here. So when were the parties married? I'm going to make this a longer term marriage. So we'll say they were married in 2020, and then they filed at the beginning of the year. So family law software is automatically going to calculate the duration of the marriage based off of the dates. And then we're going to determine if it is a short, moderate, or long term. And so depending on short, moderate, or long term, it will automatically calculate the available duration. And so in this case, these parties, the maximum durational alimony is going to be 17.11 years. So we've got 17 years in a month. So if you have an Excel spreadsheet, you could easily do this or start a free trial of family law software so you can see that. It's pretty straightforward. All right, next folder. Let's talk about net income. So net income is right here. So in this case, this number here is going to match our child support guideline worksheet. And in this particular case, maybe it's a modification case, child's or spousal support was already ordered, or there's some type of temporary award. And so what you'll see is that we take the net income from the child support guideline worksheet, we subtract out the spousal support that's currently being paid, and then so this is going to be the true net income for the alimony statute, which essentially says, do it just like you would for child support, and then make sure that you remove spousal support. And then now we know that Blake, in this case, is going to be the payor of spousal support. Right. So the question is, how much alimony is available? Let's assume that the client is Taylor. So how much money is Taylor entitled to? First, remember, need, ability to pay. Then when we come here, there's 2 numbers that you're going to see. So we discussed the easy one, which is this. Maximum durational alimony is super clear. What you do is you take the net result of the net income. So I've got net income for Taylor and Blake. I subtract that out and I get $6,727. And I'm going to take 35% of that number, of the difference of their 2 incomes. I can easily do that with a calculator, or I could do it with an Excel spreadsheet. And we now know what the maximum durational spousal support would be.
And this would not be the presumptive amount. This would be the worst case scenario, or the capped amount, the most, if everything is accurate, the most alimony that could be awarded, right?
The absolute top, the absolute maximum durational alimony. We know that the maximum is 17 years of payments, and we know that the maximum amount of durational alimony is $2,354, period. That's the ceiling. You're not going above it. So even if Taylor's need exceeded that, it would not be available. No. So that is how the statute is going to work. And then in this case, it was a long-term marriage, and we know that the duration of payments would be 17 years. Maybe Taylor's permanently disabled. Maybe she's on VA disability. I mean, like 100% VA rated disability. Would that change this? How much longer could she receive support? We don't know. It could be an exceptional circumstance. So we'd have to go over those factors. But as far as cut and dry, this is going to be the absolute maximum for duration alimony. So the question though is, how much rehabilitative and bridge the gap alimony would be available? So I'm just going to scroll down a little bit. So we talked about the easy one, which is durational alimony. The question that the statute still leaves open, in our opinion, is how much rehabilitative and bridge the gap alimony is available. And so the statute says that you can combine alimony, and the statute says that you cannot essentially leave the payor in a worse off position. What's the exact phrase. May not exceed 35%. Sorry. The exact phrase is the award of alimony may not leave the payor with significantly less income than the net income of the recipient. What does that mean?
What does significant mean? It's crazy.
I don't know. And so our interpretation is that rehabilitative and bridge the gap alimony can exceed the 35% threshold so long as it does not leave the payor with significantly less net income than that of the recipient. And so how do we calculate what we think the maximum is? You can see here that we've calculated it to be $3,363, which is higher than the maximum durational alimony. This number, I'm going to scroll up now because it's here as well. The same number is here, what we're calling the maximum combined. This is Family Law Software's answer to that question. It's a legal question. It really isn't a financial question, because if it were, the statute would outline it. And so the question is, how much can you get? What Family Law Software does is we start with essentially a flat equalization. And so we know from reading the case law that 50%, 60% of available income is too high. We're assuming that this is leaving them on even playing field. And so therefore, this is the maximum spousal support that we are suggesting that is reasonable under the statute, but you could modify this to whatever you think less is, 10%, 20%, I don't know. It's really up to you how you use the tool, but we want to open it up to the practitioners to understand that while durational alimony has a cap, we don't think that there is a cap for the combination of bridge the gap and rehabilitative. So we'll have to see what happens. There's a lot of CLEs going on. We'll have to see what the judges have to say in the case law. We'll just go.
I'm curious if the legislative meant to cap all of it at 35%, or if they did, I guess they'll be doing a fixed bill pretty quickly after they see our seminar.
I mean, the way it's laid out is just interesting, because you have the section for bridge the gap and rehabilitative, and it says you got to have a plan, and it outlines several factors, but it doesn't talk about the max. And then with durational, it was super clear what the max is. So this is what we're left with. And so this is a really great tool for you to look at, for you to play with. If you want to play it safe, this is the safe section, just stay here. If you want to try to push it and see if you can go to higher amounts, go for it. So that's what we're trying to show the users here.
All right. What about bridge the gap?
I know. All right. So we're going to go down to our last folder, which is the totals. And so what we do down here is we show what we consider to be the max and then the durational, and then you can pop into the program what they've agreed to, what's been ordered, what the start date is, and then how long it's going to last. So let's see here. So in this particular case, I put in $3,000, and for 30 years, it exceeds, we pop up a note and it says that exceeds. So if they're doing this by agreement, in theory, they could. If not, you want to lower this back down to the presumptive amount. So 2354. And then we'll take this down to, I guess, 16. We'll say 1 year less than what's available.
And your little warning goes away.
And the little warning goes away, because you definitely don't want to do that. Right. And then we do have a way to print this. So that's kind of like the super basic analysis, is talking about net income, getting to net income, talking about the duration, and then the maximums. And the last thing that I want to talk about is, where does this leave the recipient and the payor? So you can take this number and we can do more with it. So let's say 2354, let's go back to our child support calculator in Family Law Software. And I'm going to pop in the 2354 here. So I pop in the maximum durational alimony into our child support calculator. I see the child support results at the top. And then what Family Law Software also offers is visual representations about what this means for both parties. So at the top of our child support calculator, we have graphs. And so when I scroll down, we can see that before child support and spousal support, this is where the parties were. So Taylor is close to minimum wage, and Blake was obviously has a good job or high paying job. And then post-divorce, here we can see how Taylor's financial situation has improved with spousal support and child support, durational specifically. And then we see how the payor is left. He clearly does not have less income than the recipient of spousal support in this case.
Very cool.
And if you scroll down, we have other, so here, let's talk about, we've got the impact on both parties, payor versus recipient. So if I click the payor, we have another graph that breaks down the annual expenditures or how much is left. So you can see child support is a pretty small percent. Taxes is eating up a big chunk of it because he makes over $150,000 a year. And then we can see spousal support. And then this is his remaining budget afterwards. So $88,000 clearly is enough for housing. It's clearly enough for expenditures and vacations, et cetera. So this is going to show that clearly this is probably what the legislature intended, was to balance out this need and leave the payor with money to do anything, to live. So you can see that here.
Got to be able to pay those basic expenses.
You have to. I mean, there was a case in it, and the payor of spousal support was left with $1,000 a month in income, and I was like, and obviously that got kicked back. Like that's not going to fly. So family law software is going to have these visual representations, and then the other thing that you're able to do with family law software is we have other tools. So all I'm doing is taking out the unknown by using the cap of durational alimony. And then I'm going here for another support impact. So when I come here, what we're showing is Blake is paying $324 in child support. They're paying $2,300 in spousal support. And then again, this leaves both of them in an okay financial position. Taylor, not so much, because now Taylor only has $3,000. One of the living expenses were here, excuse me. So you can see that the living expenses are being met and that there's extra money to be had. All of those graphs are going to follow here. So those visual representations are at the bottom. But the last factor that I wanted to show on a side-by-side basis is if I click expanded report here, I'm still going to have Taylor and Blake's columns here. So it's all the same information, except we've broken it down further. And if I go down Blake's column, what I'm able to show, Blake is the payor. This is showing the percents of Blake's available income and where it's going. And so you can see that 26.6% of his available net income is going to child and spousal support. Only 23% of his income is actually going to pay spousal support. So this number is very reasonable. And so if you ever come here and these numbers are high, and when I say high, I mean 40%, I mean 50, 60 is just insane. But once you start getting over 30%, you really want to think about the need and ability to pay. We have some caps and we have some guidance. Parties can still agree to any numbers in theory. And so this is going to really show the financial health of the parties and if this is doable. In this case, Blake is going to be just fine paying these amounts.
Blake, you're going to be okay.
Blake's going to be okay in this particular case. And then one of the last tools that we have, and so it used to be the first tool that I used to show people in family law software when it came to spousal support analysis, but now it's kind of like the last tool is, if I go to alimony alternatives here, alimony break even. And so this, in this particular case, what it's saying is, in this case, Taylor's fine. But when you enter the financial information for both parties and you come to what we call break even, what this screen is essentially showing is what is the financial health of the parties if nothing happens. And so what you'll see is that In this case, both of them have money left over in their pockets currently, like this could be based right off of a financial affidavit and you come here. And what we're going to show is there like a break even need, like the absolute bottom just to meet living expenses. And this can be a really powerful screen to show like the bottom need. And then you can obviously go throughout the program and have other representations and printouts about how future spousal support and child support will impact the case.
Oh, cool. I love the fact that you guys are on top of this, and 2 weeks after the law is passed, you're ready. You not only have the changes to the software, but you have this presentation done.
I mean, I think that really sets us apart, is that we have attorneys and developers that work on this and interpret the law ahead of time, and then we get it out as fast as we can, because this is effective now. So the bill says for cases, filed or pending July 1. So the law was signed, on a Friday, and then became effective like that Sunday. I forget what day it was.
A couple days later.
So if you were in trial and you didn't have, anything signed by the judge or oral ruling or a mediated settlement agreement, I feel like there was a lot of chaos, and there might still be, unfortunately. So we were trying to get you guys some answers and some guidance, and I hope that we did that for you.
Well, I'm sure our listeners appreciate it. I appreciate it because family law software is the only financial tool I use in my divorce cases. And I've had a great relationship with you all since you exist. I think I might be one of the first subscribers. So thank you, Anna, for sharing your wisdom and spending some time with us and teaching us all these cool functions and telling us about the change in the law.
Yeah, thanks for having us. And we offer a free 14-day trial. So if anyone thinks this is kind of cool and you're getting some FOMO, come and check us out. And then for all of our long-term subscribers, if you ever have questions, just reach out to us through the website. It's really easy.
And we just had Anna train our entire staff a couple weeks ago, and over lunch she came in by Zoom, and now my whole team is proficient with all the changes in family law software.
Awesome.
So thank you, Anna, and this concludes this quarter's CLE. Hope to see everybody next time.